Good evening, everyone, and welcome back to our SFT Migrations webinar. It's good to see you guys again. Today, we do hope that topic and the content will be helpful to everyone. Just a bit of introduction to SFT Migration for those who haven't joined our webinar before. SFT Migration is one of Australia's leading migration consultancy firms, and we have our head office in Melbourne and with branches in Sydney, in Taipei, and in China as well. And our team, we have many registered migration agents and also our partner legal firm, which is Proactive Legal, headed by David Gu, is a very experienced solicitor in the field as well. Whenever we handle the case, you can be assured that we handle with the top quality expertise. Back to the topic for today. We will be looking at in details the issue of partner visa. Obviously, we all know that if you have a partner, a spouse, a husband, or wife, or a de facto partner that is an Australian citizen or PR, then you might be eligible for sponsorship to become PR yourself. But that is very basic knowledge about partner visa. But in the events that the partner visa is not normal, there are issues, there are problems within your visa applications or your relationship, then the issue get a lot more complicated. And in the regulation, there are clauses and regulation provided for such circumstances, which Sean will discuss with you today regarding those scenarios. And our speaker is Sean Zhong, the director of SFT Consulting Group and also SFT Migration. Sean is a registered migration agent himself, and he got a master in law from ANU and a master in migration law and practice. And Sean is also a regular policy commentator on ABC. In terms of today's content, Sean will cover more advanced matter regarding partner visa, specifically about the insight into the genuine and continuing relationship, because obviously when we present the documents, the evidence to the Department of Home Affairs, case officer always look into the genuinity of the relationship. So this is also a very important factor. And during the relationship, not all relationship went well. Obviously, there are breakdowns, there are ending of relationship, and of course, there are domestic violence. So what are the circumstances and what are the options available to you when you experience these situations? And in the migration law and regulation, there are clauses and regulations specifically designed for this situation. So Sean will discuss about that. And can you get a partner visa after you get refused or become unlawful citizen in Australia? And it's really regarding Schedule 3 and Section 48, if you know about that. But this is quite advanced issue to discuss about as well. And finally, in the event that you have a refusal on your partner visa, the next possible step would be to apply for the tribunal review at the AAT. So between the time that you apply and the time of the hearing, there are quite a long duration, so it can take 1 or 2 years. So during that time, what kind of evidence tips you need to prepare in order to have a chance of success at your hearing at the AAT? So please welcome Sean.
Okay, thank you, To. Thank you very much. Today we actually we might host another session talking about all the evidence, but today we are here to talk about all these complicated issues. I understand a lot of people wanting to apply, obviously this year because of COVID, the new budget, I assume everyone had seen it, many of the GSM quota have been moved to partner visas. So we're assuming that the partner visa will be processed much quicker. My session, I will talk about some of the complicated issues and misconceptions of family migration. First thing I wanted to emphasize on the definition or on the basic foundation that you are applying for the partner visa. You got to be a partner. But there are differences in the partner concept. Firstly, of course, there's going to be a married relationship. So you have to be married to each other before or at the time of visa application. So if you plan to get married, you better do that before, all right, before making the visa application. So that's one key. Timing is very important if you wanted to go as a spouse. We're going to talk about de facto partners, but spouse getting married first. And then the key thing is that a relationship must be to the exclusion of all others. There are situations that people have open relationship or have another relationship during the period, and some people may be sharing the stupid photos with different people for the different timing, and sometimes that get exposed. And case officer, trust me, they sometimes look for evidence with that. And when they detect something suspicious, they might go out and send you a natural justice. See, there are adverse information against the relationship. So they might accept that your current relationship is genuine. You're married, no problem with it. And you're not in a fake relationship. But if they prove that there's another relationship of a similar nature, you fail, basically, because there's a important concept is to the exclusion of all others. You may have a different attitude of your life. Maybe your partner would agree that you can see other ones if they're quite adventurous, but that won't satisfy the partner visa requirement. And again, another thing is, even though you're married, you still got to prove that the relationship is genuine and continuing. Why is that important? Remember, if the delegate wants to refuse you, they have to find a reason. They have to outline the reason why you do not satisfy the legislation, which is Schedule 2 requirement, which of these requirements you don't satisfy, and that's why your visa is going to be refused. Obviously, you're married, you don't have any other relationship, but if they are not satisfied, the relationship is genuine and continuing, they can use it to refuse you. So I guess that's a very tricky bit, that how do you prove your relationship is genuine and continuing? It's important to provide as many of it as evidence as possible. And also, do not assess your case. Sometimes there are risky cases. For example, the age difference is huge. I'm not saying that's not okay. It's okay. If there are 20, 30 years of age difference, it will raise questions. So you have to prepare your case more carefully in the highest in a more risky category. And also, you have to show evidence of all of those 4 aspects that Sissy discussed. And also another thing is that you have to live together. If you're not living together, you have to prove that you are not separated on a permanent basis. What does that mean? So it means that you could sponsor someone and get married and work in a different city or in a different country, as long as you prove you're not living separately on a permanent basis, frequent visit to each other, and also, a good explanation because of work commitment, etc. Those things are acceptable. But again, you have to understand the psychology of case officer. They don't see you. They don't meet you. Whatever they see stays on the paper. So AAT is different. They're going to see you. But unless there's an interview, whatever they decide will be based on the paper you file. So how to build a case that is convincing is important. And when you stay in different countries, if it's one of the countries is not Australia, that the case officer will see that from your movement record. And sometimes people do that afterwards. You got the 820, but remember there's another stage of 801, which is a PR stage. And sometimes people just don't stay together for numerous reasons. If you didn't do that, if you live separately on a long-term basis, or very frequently you're not together, remember to prepare for that when you lodge. Because when you lodge a case, the first impression to the case officer is very important. If your first impression was good, you probably face less scrutiny or checking. But otherwise, if they have questions, they will look into it, and they might conduct phone interviews or face-to-face interviews or even door-knocking visits. If you're in a genuine relationship, you might not be afraid of it. But let me tell you that even if you're in a genuine relationship, those investigation creates more chaos and sometimes possibility that you might got a problem. So you might, when they visit or when they call you, you're just not together, or you don't answer the questions confidently because you have language difficulty, for example. That could be causing a refusal. So although this legislation is simple, but you have to read it carefully, find what's important, what are the key things they're looking for, and what can be the weapon that they use to refuse your case. That was spouse. I already said the timing is important. If you got married after after the making the application, you have to prove that at the time of this application, you were in a de facto relationship. Because very simply, there's a time of application criteria. At the time of application criteria, at the time of visa application, you either have to be married or you have to be a de facto partner, as explained here. If you were neither of those, you apply for it, but get married later and have baby, you still wouldn't satisfy the time of application criteria. So it's very important, if you didn't plan to get married, understand what the de facto partner means. Very similar, share life exclusion to the others, relationship genuine continuing, live together, but there's also a very important timing thing. So applicant has been in a de facto relationship for at least 12 months, ending immediately before the date of application, unless it is registered. If your de facto relationship was not registered, you have to had already lived together as a couple, not only as boyfriend and girlfriend, but as a de facto partner, which means the four commitment. Remember, we discussed, it's a second line here: financial, household, social, and nature of commitment. Those must satisfy that. You have to produce evidence. All right. So this is quite inflexible, I have to say. Don't just assume as long as you live together, your relationship is continuing, you'll be fine. Timing is also important. You have to prove those whole 12 months. Otherwise, that can be used as a reason to refuse you. However, the solution, of course, is to register relationship certificate. Cici already discussed. And magically, if you register after making application, that still counts. But you must have the relationship of de facto relationship at time of visa application. The registered relationship certificate only waive you the 12-month period, and that can be submitted after you lodging your partner application. But remember, you must prove those evidence at the time of this application. All right. And the last point I want to make is that a lot of people, decided to separate with your current partner and moving on to the next one. And in Australia, there will be a 1-year cool down period that you have to live separately. And during that separation period, you can live together with your new partner and accumulate your relationship. You can even lodge the visa if you had already got 12 months before you get divorced. So you can sponsor your new partner before the divorce is finalized, as long as you were separated already and you had been in exclusive relationship with the new partner for 12 months already. Okay, is that a little bit confusing? But anyway, most people are not in this sort of difficult, complicated situations. But if you are, just remember my words, be careful. But you can do it before the marriage is over. The previous marriage was officially, divorced. But of course, if the relationship was ongoing or, and you just currently living with another person, that doesn't work because that would fail the exclusion to the others requirement. So these are a few things we wanted to discuss regarding the relationship. Now, let's move on to the next one. We always prepare, you were told to prepare a love story describing your relationship. So I guess a lot of people focus on, in their statement, focus on how much you love each other. I think probably most of you in front of the Facebook live stream would assume that is loving each other is the key. Well, that has been tested at the court. So this is a case, okay? Very important case in 2016, talking about whether love is an important or component in a genuine spousal or de facto relationship. And, the interestingly quoted Frank Sinatra's song, love and marriage, but they confirmed that love is not a compulsory component. Okay, or a determinative. This case was basically between an old Australian man and I think a woman from Indonesia or the Philippines, I can't remember. They were in a relationship to the exclusion to the others, but they don't have romantic love after, examining the evidence. Basically, what the sponsor said is, I sponsor her. I'm married with her because I want her to look after me. I want to find my husband to support me to living a good life in Australia. That's why we live together. Look, Obviously, they didn't intend to present case that way. There had been, trap stuff and etc. The in picture was like, and it was decided that the romantic love is not a determinative factor. And between them, although their relationship had not been with a sexual or romantic relationship, but all the other evidence, living together, social aspect, your commitment to each other, they're all satisfied, then that's fine. So look, here's the thing. I'm not telling you that you don't have to present love. Presenting love is important. It's good. It helps your case, but it's not necessary. I guess what you need to focus on is all the 4 aspects. All right. Don't spend too much effort or all your effort on love, which is sometimes very difficult to justify because so subjective. It's intangible. But what is tangible is your commitment to each other. The money you spend, the life plan, the visits you made, how your friends know you. Those are the key things. All right. But another point I wanted to make is when your case is in trouble, when you're having difficult cases. I just had a consultation on Monday. That was quite an interesting case. She may be listening to this now, but what I'm trying to say is when your case having some difficulty or complication, it's important to plan your case in a good strategy. You have to focus on the key element of your case to win the visa application. If you're spending like 90% of your effort on something that is not relevant directly to your case, then you're probably losing your opportunity. All right, so I think Cici already discussed about the bridging visas, but just I wanted to emphasize it again. A lot of people holding student visa, lodged a partner visa, and didn't want to study anymore. All right, but you have to remember, if you are still a holder of your student visa, the bridging visa A or C or whatever, usually it's C, it's A. If you're talking about your having a substantive visa, it would be bridging visa A. Your bridging visa A will not come into effect. Cici and To both emphasize that. That could lead to visa cancellation, particularly student visa. But how do you resolve it? I think the easiest way to apply for another substantive visa that is shorter, replacing your previous bridging visa, e.g. a 600 visa. Once that visa is granted, and then your student visa will no longer exist because a new substantive visa will replace the old one. And then the quicker you get on the bridging visa, the quicker you can work on full-time basis, the quicker you don't have to study if you didn't want to study. You don't want to cancel your student visa voluntarily. Of course, firstly, you can't do it while in Australia. They won't do it. If somehow your student visa was canceled, for example, if you didn't study, said, I don't care, that will not impact your partner visa application. Okay, that won't lead to refusal because that's not relevant because you already lodged your partner visa. But you have to apply for bridging visa E because your previous visa was canceled. When substantive visa was canceled, like student visa, all the associated bridging visas or any bridging visas you hold will be canceled at the same time. So you have to apply for bridging visa E, which will not allow you to travel, to study, to work. If you want to apply for your rights to work, then you have to demonstrate that you have compelling reasons to work, which if your sponsor is rich, then you can't. So yeah, that's regarding that. And another interesting point I wanted to make, we're in deep waters. These are the things that maybe a lot of non-migration agents would know, but I wanted to touch base here. So, but be careful. When you're in a difficult situation, I've had a case that had a relationship breakdown in between. Will that necessarily impact your visa application? Well, no, because legally speaking, when you apply for partner visa, they only look at your relationship at those time points, which is visa application, time of decision of the temporary visa, when you submit further information for the PR, and when they assess your PR. During these times, your relationship must be continuing and genuine. But what if in between, no one's looking at you? There had been a breakdown of the relationship, but you got back together. What I'm trying to say is, of course, you don't want that to happen. But if that did happen, if the department actually discovered that, or there were mutual exclusive relationship issues, you could try to argue that those relationship breakdown had happened, because you don't want to provide misleading information. That'll directly trigger refusal. So you might have a better choice if that happened during a particular period of time that no one looking at your case. You just admitted, yeah, it broke down, but we got back together. Now we are in a good relationship. You could get away with it. With at a department level, many of the case officers are not legally trained, but at a tribunal level, you got a better chance. At the court, you got a much better chance as well. But look, I'm not saying that this is what we suggest you should do. This is what you do when shit happens. You could work out some of the solutions, but what you don't want it to do is to provide misleading information, false statement. I'll share something later. Now, the next question we want to discuss is that when relationship ceases, what happens? I'll give you an example of the cases that I handled. The relationship was genuine, of course, and they applied for partner visa, broke down, and then got back together. 820 was granted. They had a child, all right? But then the sponsor met another man. I think things are just not working out. The relationship broke down again. They actually got divorced. The divorce happened before they launched further information for the permanent visa. And they didn't tell us. The applicant didn't tell us. The sponsor didn't tell us. The sponsor want to help the applicant to get PR for the sake of the child. So neither of them told us. The sponsor was cooperating, of course. And then the department somehow discovered that they got divorced already. And I asked them, they show me the divorce paper. The divorce paper was before submitting further information, including statutory declaration of the relationship is continuing for the PR. Relationship broke down, divorced, provided false information to get PR. So the department discovered that and sent over not only that your visa should be refused, but also a public interest criteria 4020, you provided misleading information. And then we were shocked when we look at that because we didn't even know. How do we handle it? We told the client that, look, you have a child. You actually have a child. Because you have custody or access to your child, you're eligible for PR already. You just didn't tell us. If you told us, we would tell you. Anyway, so you're eligible for PR. Then there's another thing with the 4020. You actually provide this misleading information. You can't argue with it because the divorce paper was there. We told them, look, let's admit it and seek waiver for the 4020 because of child. And that's what we did. And the sponsor wrote a statement explaining her thoughts. It said, look, I did lie, okay? But I was lying, trying to help him to get PR for my child, to stay here with my child. I didn't know you could get PR even if the relationship break down if you had a child. And that was then, visa granted. So simple as that. Waiver was granted because of child and relationship breakdown, admitted, but you can still get that granted because of child. So I already give you an example when you have access to a dependent child, even if the relationship breakdown, that's fine. But also there's family violence occurred. If family violence occurred during the relationship, you can go to PR as directly as well. Partnership, if the partner died and if 820 already got granted or 309 got granted and the applicant entered Australia, then the partner died, sponsor died. As long as they prove they have developed business, cultural, personal ties with Australia, the PR can also be granted. So those are the general things after relationship ceases. But look, I hope no one will get into the situation of family violence. But I wanted to quickly talk about it if you had that situation, because no one wants to be intimidated, blackmailed for PR and get, bullied during the relationship. If that really happens, you can't get PR without continuing your relationship. But the requirement is that the family violence must happen after the 820 has been launched. You didn't launch your visa and you were in a relationship, you were on a student visa and the relationship broke down and the violence happened, that won't help you with the visa. But if you launched it, even if 820 was not granted, family violence happened, that's acceptable. You're eligible for PR, okay? And another important thing is that the violence must happen during the relationship, okay? What happened is that if you apply for 820 visa, you're still within the relationship and the sponsor ended the relationship, and then family violence occurs. I would say I sympathize you. It's very unfortunate, but that won't help you to get your visa, because all of the cases they look at is there really important keys that violence must happen during the relationship. So when you try to present a case to the department, if you tell them, look, I end the relationship, I moved out, but he chased after me a few days later and violent, hit me, etc., that won't help your case, because the department would say your relationship ended, ended before the violence happened. So very important factor, violence must happen during the relationship. And there are two types of family violence. One is called judicially determined family violence, which is considered by the court, and the court decided it's family violence. Then you have nothing to worry about. That's end of the story. So when you're hit by your partner, don't be afraid to call the police and let court decide that. If the court decided on your family violence matter, decide that is family violence, the department cannot say no to it. But if that's not the case, not judicially determined, you may still be able to claim your family violence. It's a much more complicated process. There's a definition in regulation: misconduct, threaten towards the victim, a member of family unit of the victim, and property as well. And also there are psychological violence. We won't go into the detail because it's such a big topic. But you probably need to ask a psychologist to assess if there are issues, or ask family consultant, women at risk support people if you are suffering that. Family violence does not only apply to women. If you're a man, you may be a victim of family violence. Important thing is that you may have made a lot of claim and evidence, but if the department does not accept you or believe you, or does not satisfy with all the evidence you provide, and doesn't think that your relation that is enough to be family violence, an independent expert assessment will be required by the department. So they will assign a psychologist, and the psychologist will give you assessment, and they will decide whether whatever you told them is enough to satisfy the requirement of family violence. I can tell you that sometimes independent expert can be quite biased. Particularly your English is not your first language. A lot of things can be lost during the translation, and sometimes people are biased. They just don't assume your claim is genuine. They thought you just try to get PR, and then it's gonna be hard. So remember, if you want to go there, prepare that case, okay? Prepare the case. Another important thing is that you have to decide, remember there was an element that the violence must happen during the relationship. It is not the expert's role to determine when the relationship ended. It is his or her role to determine when the violence happened. They can do that. And then it is the department officer delegate's role to decide when the relationship ended, of course, with evidence you provide. So remember, there are jurisdictions and roles of that. And to lodge that family violence claim, you have to provide a bunch of evidence. Two types from those types, like medical report, police report, child welfare authority declaration or report, women's refuge letter or assessment report, social worker statutory declaration, registered psychologist declaration, and family consultant statutory declaration, school principal, school counselors statutory declaration. So you have to prepare two of those types. You can't just prepare your own stat deck and assume that's enough. That's not enough. You won't be able to make a valid application without those evidence. That's enough for family violence. Now, let's talk about two other important matters. That is, one is called Section 48 bar, the other is Schedule 3 requirement. So Section 48 bar bars people from making a valid application. So according to Section 46, you have to satisfy Schedule 1 requirement if you want to lodge an application. But if you are impacted by Section 48, you won't be able to make a valid application. That particularly means that if you're in Australia, if your previous visa had been refused or cancelled after your last entry, and you're not holding a subtended visa, e.g., you don't have any visa or holding a bridging visa, you won't be able to make a valid application for a new visa onshore, except for a group of visas. That group of visas includes partner visa. So Section 48 bar does not bar partner visas. If you're lodging it the first time, if your partner visa hadn't been refused. If it hadn't been refused, sorry, it won't help you because that you won't be able to do it repeatedly. But if your previous visa, student visa got canceled or refused, or you're unlawful, if you can demonstrate you have 2 AAA forms, you will be able to make a valid application. That's Section 40 bar. It's about the validity of a requirement. The second thing is Schedule 3. Schedule 3 requires that at a visa application, at the time of visa application, you must be a subtended visa holder. If you are not holding a subtended visa, e.g., you don't have any visa or holding a bridging visa, then you could be subject to Schedule 3. And Schedule 3 is basically about 28 days. You have to lodge your partner visa within 20 days of your previous visa, subtended visa expiry. Or if you didn't, you apply later, you must satisfy the minister there are compelling reasons for not applying those criteria. So a lot of people would be impacted by this. If you're on AET, for example, then you could be subject to Schedule 3 waiver, and you have to demonstrate compelling reasons. The compelling reasons is not a very low threshold. It is rather a high threshold. You have to tell them why on earth you cannot lodge your application offshore, why you have to stay here and lodge it. And if you didn't lodge it onshore, there could be devastating results to Australia or to Australian citizen or PR, or other, compelling reasons. There are not particular examples, but if you have a child, a young child, of course, that's a very good example of compelling reasons. If you are the sole bread maker, you're the person bringing all the money for the family. If you depart, your family will be in trouble because they don't have money to survive, pay rent, etc. Yeah, that's another good compelling reasons. But you can't just say, oh, I miss her, I miss him, I can't live one day without him, but purely based on that on a claim. That's not enough. And you won't be able to do that. And if you doubt that you would satisfy the Schedule 3 requirement and you're on a bridging visa, you're on a AAT, for example, but you're certain that your relationship is genuine, you just don't want this extra risk factor, what you can do is you can apply for bridging visa B, depart Australia, apply for 309, which is the offshore visa application. And that one, you're not impacted by the Schedule 3 or the Section 40 bar. The downside is that you won't be able to have a bridging visa after your AAT is decided. Of course, if you go for judicial review, you will be able to continue. All right. But you can come back and wait for your visa. But if you lodge 309, the 309 requires you to be offshore when the visa is granted. So you have to depart. But the department will tell you they're ready to grant, then you have to depart. Those are under normal circumstances. Under COVID, it just makes things a lot more complicated. But I don't see a straight solution at the moment. So yeah, that's the situation about Schedule 3 and Section 48. I just recently saw a decision made by a case officer from Cambodian post of the DFAT. The person mixed together of the Section 40 bar requirement and Schedule 3, which is interesting. So, but anyway, let me tell you that many of the offshore case officers are not well trained. They sometimes make very stupid claims, and decisions. I've seen a trend that Vietnamese nationals, their onshore visa application will be assigned to the Ho Chi Minh City Post, for example. And those decisions made by those DFAT officers are quite different from the Australian style. And it sometimes can be ridiculous. All right. Challenge it at AAT, at a tribunal, if you think that's really unfair. And sometimes the claims are not very logical. What's important is that at AAT, you have a new chance to present your case and make your arguments. So you can fix it. All right. And another thing I wanted to discuss regarding Schedule 3, compelling reasons. It used to be a time of visa application criteria. Actually, it used to be time of decision criteria. Then it changed to be a time of visa application criteria, and then changed back to a decision criteria by a court case. What I'm saying is in English is that you can demonstrate your compelling reasons when they look at your case, either at the department level or the tribunal level. You can show them that this is your situation. For example, you apply for the partner visa without any special reason, but you are not a holder of substantive visa, and your visa got refused, and you apply for AAT, and so many years has passed, you already had a child, or situation significantly changed. So at the tribunal, you can present your case, you can present your current situation to satisfy compelling reasons. Just a reminder. Lastly, some of you, if your friends are at AAT, you have to be careful doing the AAT. I understand AAT is a difficult, it's a different battlefield. A lot of migration agents who are not experienced or have no litigation knowledge or experience wanting to do the AAT for the clients. They can if they want to. But look, in that battlefield, if you are not equipped with the biggest guns and be trained with a lot of experience, it's more likely you're going to get shot and killed. So it's difficult because your case will be interviewed, interrogated, asking questions separately, checking for inconsistency, or focusing on some particular legal issues. Example is time of application, time of decision criteria. If you don't distinguish that clearly enough, it's wrong. You won't be able to win. And, you have to provide sufficient updated evidence because so many years have happened. You have to prove your relationship is continuing. But remember, of time of application criteria, if you might have to prove that your relationship was there before at the time of its application. And sometimes they will question you. Most of the time, if they have suspicion regarding your relationship, they will ask you separately and looking for inconsistency in your answer. Will things be 100% consistent? If your relationship is genuine, it is less likely or almost impossible for everything to be matching 100%. That's a reality. How can you prove that everything you answer, unless you prepared everything over and over again, that everything's genuine? But the way you answer it, the degree of inconsistency will affect the decision maker. And also, I remember I had an important case that you sometimes have to play mind games. I had a Schedule 3 case years ago, and the applicant also had serious health issues as well, and visa cancellation, Schedule 3, etc. They do have a child, and I asked them to bring the child to the tribunal hearing. That definitely plays a part in the decision maker or the member's head. So you have to prepare your clients, because the migration agent won't answer the questions on behalf of the applicant. It is not court hearing. Tribunal hearing is about the questions that your applicants answer. The migration agent's role during that hearing is quite minimal. So I think the important role for the migration agent is to prepare a written submission earlier to address all the legal issues and key reasons and build up the foundation or impression you wanted to achieve for your case, for your applicant, and then prepare your applicants during that interview. And that's the thing. And if you have serious Schedule 3 problems after you lodge it, but you don't know when your case will be assessed and you're rich, during that bridging visa for your first partner visa, you can depart Australia and lodge another offshore visa. You can do that. There's no problem doing that. And it's just really expensive. That's all. But if you can afford it, you can do that. So in that case, you will have double opportunities. Whichever get decided first, then you get a safeguard. Anyway, this is only applicable in difficult situations, and we wanted to tell you that we're very experienced in those situations. And that's pretty much what we want to discuss today. And I understand it might be quite dry, but look, it is quite a complicated case and situation. So now let's do the Q&A time.
Thank you, Sean. And I believe those are very helpful information, especially what Sean has discussed. So if you ever find yourself in the situation of domestic violence, ending a relationship, those that Sean has discussed before, then you are aware that there are situations, there are circumstances and options for you available. You can seek professional advice to discuss your case. And just back into our Q&A times, and we have quite a few questions.
Well, remember, you have to satisfy all of those 4 aspects. You can tell you love each other very much. You are in a relationship as boyfriend or girlfriend for 10 years. But if you don't satisfy those 4 aspects, especially the financial commitment, you won't be able to prove that it's 12 months. Of course, you may be able to prove your commitment to each other in those 4 aspects, providing any evidence. I'm not saying that a joint bank account is necessary or 100%. It's helpful, it's really helpful. But otherwise, I don't know how you prove your commitment to each other in financial terms. You certainly can, but it's just a little bit more work. In that case, I suggest that you should try to register a relationship to reduce the risk of 1 year. Then what you need to focus on is same as you getting married already, the genuineness and continuousness of the relationship. So you don't have to worry too much about the 1 year.
Just be aware of the sponsorship limitations. With the information we have here, there's only 2 sponsoring application. It's not the 3rd one, so that's fine within the 2 number of application, which is the limit. And just be aware of the time, which is the 5 year between the day of the first sponsorship visa application was made and the day of the approval of the second one. So make sure it's 5 years apart. And I believe your sister boyfriend can sponsor my sister now.
Well, there's no requirement that your previous application, other visas have been rejected before. I've discussed that in section 48 section. I've said partner visa exempted from that restriction. So if your partner visa, if you haven't had your partner visa rejected before in Australia after your last entry, you can make a new application. I think there's another question saying that I'm currently got refused a student visa on AAT, still pending, and now wants to apply for partner visa. You can do that, no problem. The only thing is that the Schedule 3, you have to satisfy that, which is you have to satisfy that you have compelling reason to lodge that application in Australia. I think that might have been this might be your correct question, whether the COVID will become a reason that you cannot depart Australia. Well, you could, to be honest. So we don't know how the COVID will become a compelling reasons, whether it will become a compelling reasons for Schedule 3. We can definitely try to argue that there's no flight. You have to do it. But look, it's not completely no flight situation. So, we'll see how things will work out. But remember, if you're currently pending a review, or if you're currently pending for a new visa and hasn't been granted yet, you're subject to Schedule 3, and you need to provide compelling reasons so you can make that application onshore. Actually, correction, you can make that application onshore without any problem, but you have to satisfy them for the visa to be granted. So you can make a valid application, but whether they're going to grant you, that depends on whether you can satisfy them. You had compelling reasons. So it's complicated. We have to look at your case one by one to decide. Yeah.
Thank you, Sean. Always remember that with cases with refusals and with unlawful season is very complicated. And we always suggest that you seek professional advice regarding your situation. And it can be difficult to give advice with so little information available with these type of questions. Thank you for attending the webinar, and we do hope that you will find it useful. And if you have a preferred topic that you want us to present in the future, you can inbox our Facebook with the topic request, and we will try to deliver it in the next webinar event. So thank you very much and have a lovely evening.